Employment law. This PowerPoint is divided into 3 modules: employment at will, exceptions to the employment at will doctrine, and then an exception to the exceptions to the employment at will doctrine. This topic often has students asking questions like, why is the minimum wage so low? Why can my employer do this? Why can my employer do that? Why is the law this way? These questions illustrate the difference between politics and law, or political science classes and law classes. Law is about the existing state of whatever the government tells you to do, because, as we learned before, laws are standards of behavior set by the government. Politics, on the other hand, is related to, or at least is more related to, control of the government. It's true that the way to control the government is through the laws. We study the laws after they have been adopted. Politics looks at the way people and organizations use the political process in order to gain control of the ability to make laws. If you can control the laws, then you can force people to do things they may not want to do, such as pay overtime or not discriminate based on some physical characteristic. This topic is beyond the scope of this class, but you may want to think about it as you go through your law classes. Many of the rules that we cover, particularly in this PowerPoint, cost businesses money and increase taxes. These make businesses less profitable, and so therefore there is a tendency for businesses to use the political system to try to control their costs and make the laws such that it benefits them. And unions and people also try to use the political system to try to control the laws to favor them or their constituents. The rules in this presentation cover employees and agents, but not independent contractors. For example, there is a law that says employers must withhold income taxes from wages paid to employees and agents. However, this law does not cover independent contractors. This is one of the reasons why many businesses try to characterize their workers as independent contractors. However, the IRS is very careful, and there are many basic rules that have to be followed in order to qualify as an independent contractor. Employers must also pay Social Security and workers' compensation insurances for their employees and agents, but again, not for independent contractors. I do want to note that not all states require employers to buy workers' compensation insurance to protect employees from on-the-job injuries. However, the employment at will doctrine is pretty harsh. Basically, it says an employer can fire you for any reason or no reason. They can fire you because you're a woman, or if you're sick, or if you get pregnant, or if you're in a wheelchair, or if you're too tall, or too short, or too fat, or too whatever. Any reason means any reason. This is a pretty drastic rule, and over the years, many exceptions to this rule have arisen, and we will study the major ones. But I do want to point out, unless you fall into one of the exceptions to the employment at will doctrine, the law is still employment at will, and you can be fired for any reason or no reason. Next, you will see a couple of short videos. One is just a spoof on employment at will, and the other one is an actual case where a person was fired for wearing a Green Bay Packers tie. In this case, Smith, who was an operations manager at the Pillsbury Company, received some email messages at home, like most of us do, related to our employment, and he replied to his supervisor by email from his home. The messages to his supervisor contained some pretty provocative language, including the phrase, "kill the backstabbing bastards," and a reference to the upcoming company party as the Jim Jones Kool-Aid affair. This example is from an actual case, and a little bit of background information is necessary in order to understand it. Jim Jones was a cult leader in the 1970s. He convinced his congregation of more than 600 adults to kill themselves and their 300 children by drinking poisoned Kool-Aid. Since that time, the term drink the Kool-Aid or Jim Jones Kool-Aid affair have come into the vocabulary. It usually means something like someone who is willing to do anything for their boss or their company, even if it amounts to a poor decision. Pause here and answer some questions on employment at will.